Good morning. Stephen Rappaport for Humberto Guzman.
Whose appeal is this?
I thought it was the Commonwealth's, frankly. I mean,
I think
initially it was mine, but I've been told that I'm the appellant, so
Don't believe everything you hear.
I'm ready.
My understanding was the Commonwealth went first, but am I incorrect?
That's what I thought. But
The Commonwealth goes first. Doesn't matter. According to Ms. Mellon, she says you go first. I always listen to Ms. Mellon.
If I could go back to that distinction that I made in the last case ages ago about exculpatory evidence that speaks of the defendant's likely or potential innocence versus exculpatory evidence that raises questions about or that impeaches the testimony of a Commonwealth witness.
Yes, Your Honor.
Is that what you're saying here is the distinction, or are you saying something different?
I'm saying something almost exactly as the Court has described it, as Your Honor has described it. And the place where the statute shows us that that is the case is in the reference to actual innocence in the gatekeeper provision itself. If you look at the statute and you look at if you look at Section B, 1B, little 2, on grounds which tend to establish the innocence of the individual as set forth in Clause 6 of subsection C, which is the definition of actual innocence. The Court makes it clear not only, and then, of course, in Section 6, actual innocence is defined as he did not commit the crimes or crime charged or any related felony. But the fact that not only is innocence defined in the statute, that he did not commit the crime or crimes charged, but it's actually referred, that definition is incorporated into the gatekeeper provision itself. Makes it clear that it's not any kind of legal innocence.
Okay, but
It never uses the term actual evidence. I mean, right?
Well, did not commit the crime or crimes charged is actual innocence. I mean, I think that this Court has already ruled that that's what actual innocence means in other contexts. But that's absolutely correct, Your Honor. I apologize. Your Honor is absolutely right. The phrase actual innocence is not used explicitly.
I mean, I go back to I've got statutory interpretation. That's all I've got here, right? All I've got here. And it would have been very straightforward if you had had a pardon or provision that says being granted judicially by a court of competent jurisdiction because, you know, he didn't commit the crimes, or in the view of the judge, he didn't. I mean, we've got this little tend language.
Your Honor, I have been concerned about some of the conversation that we've had during this oral argument about references to the role of the criminal court and whether going forward the criminal court will be giving us our guidance about whether a judicial decision in a criminal case should be considered one that tends to establish innocence in a later compensation proceeding.
Right.
And I would suggest that this statute went to great care not to give to the criminal judge the obligation of making this decision.
Or the opportunity. I agree with you.
Or the opportunity.
I agree with you, although in this case it wasn't yet on the books. I agree with you.
Oh, absolutely. And there was a claim of actual innocence, an explicit, and not in this case, in the earlier case, there was a claim of actual innocence.
But here, the facts here are a little different, correct?
Absolutely. Now,
I'm sorry. Are you saying that the legislature didn't intend that the grounds on which the motion judge ruled are to be critical in determining whether or not the gatekeeper are the gates opened?
Not at all, Your Honor. The only concern is that in ways that could be helpful to either side, there is a danger that the criminal justice process, now that a statute exists that allows for compensation in the civil context, that in ruling on motions for a new trial or in making appellate decisions, courts in the criminal side might be influenced by the potential for their decision to be interpreted one way or another in the civil case, in any later civil case. And it's really important that the burden always be placed on the Commonwealth to prove guilt beyond a reasonable doubt, and that a defendant in a criminal case is never required to assert evidence of his actual innocence. That is
Well, I
not
understand
something
that, but I
courts
mean,
do.
but if I'm the motion judge below, and there's a motion for a new trial.
Oh, in the
and-
civil
and I-
case.
and- No, in a criminal case.
In the criminal case,
And
okay.
I find that the Commonwealth failed to reveal evidence, or there's newly discovered evidence of DNA or of an eyewitness that the Commonwealth failed to reveal, and I think that that raises serious doubt as to whether this defendant is guilty of the crime. Are you saying that you still have to go to the underlying record to determine whether or not the gate's been opened?
Your Honor, I think you almost never have to go to the underlying record, but I think it's available. I think it's part of the case before the motion judge and part of his ruling.
Are you suggesting that a judge in ruling on a motion for new trial would, what you don't want to have happen is that the judge would deny the motion for new trial because he or she is worried about the impact of that on the civil case?
It's really hard, Your Honor, to imagine the ways that the
There should be,
criminal process
there
could
should
be
be,
affected.
in one way, all we have to look at is why the Commonwealth didn't, why the Commonwealth nonplussed. What was before Judge Louse was motion for a new trial. She grants a motion for a new trial. That is not, that's just a motion for a new trial, and the Commonwealth gets to try the defendant again.
Well, but ordinarily, I mean, of course, the trial judge has got to explain why they've granted the motion for a new trial. The Commonwealth has a right to appeal,
Right.
right? So,
Correct,
yeah,
but
the
what I'm
trial
saying
judge
is-
should be explaining, of course, what
Right.
the basis are, and
Right, but I guess
That's my point, Justice Cordy. Then the Commonwealth can decide to appeal it. It just so happened in this proceeding, the two were back to back in the same
That's correct, Your
proceeding.
Honor.
That's unusual.
Not
It
this
is.
one.
Oh, no, that's the other case. I'm sorry. It didn't happen here.
This happened.
But in this case, I'm sorry, in this case, the motion judge found that the testimony that was not revealed because of the conflict of interest was, quote, crucial, and was of major importance to the central issue in Guzman's defense, that is, mistaken identity. So did the trial judge essentially find that the conflict of interest here meant that there was a serious question raised as to whether or not they got the wrong guy?
I think that in this case, both trial defense counsel and the motion judge and the appeals court discussed this as a defense of mistaken identity. The question was, who possessed the cocaine with intent to distribute? And because possession of cocaine with intent to distribute is not an exclusive crime, more than one person may have constructive possession. This was a constructive possession case.
It is
two
also the
persons-
case, it's not implicit, at least in some of it. You keep saying it's beyond dispute, I think, that large quantities were found in his possession. I mean, I thought what we had here was claims that police officers were lying. And who knows where it was, or whose it was, or whether it was there, or whether it was placed there. Wasn't that what was going on here?
That was later.
Your Honor, if Your Honor is referring to the indictment of the police officers, that is not strictly relevant to the question of what were the grounds on which the new trial was allowed, and the appeals court affirmed that order. At trial, yes, credibility was raised, Your Honor, but there was no suggestion of theft from drug dealers. The investigating officers who investigated Mr. Guzman's case stole the money. They seized from both him and his co-defendants.
They obtained or did not obtain false affidavits?
There was no allegation of that in this case. This case was actually listed, and the record contains the federal indictment, and so the court can look at the pages they're referenced in our brief. But it recites how they seized cocaine from Mr. Guzman, they seized money from Mr. Guzman,
From
and they
his
stole the money.
person?
No, from his, some money he was out of the country at the time of the execution of the search warrants. His co-defendant, Mr. Diaz, arrived with over $1,000 in his pocket. That money was seized. And in addition, the safety deposit box that the bank officer testified only Mr. Guzman had access to, and there was a signature card, and it wasn't disputed that it was his money. There was over $40,000 in cash in that location also. So that was stolen. But there wasn't an allegation in the federal indictment of, I mean, the scheme was to steal from real cocaine dealers because, of course, they're more vulnerable. They're not going to go to the police and complain of the theft. But
in any event, the appeals court was very specific that it was making its decision based on the motion judge and not on the subsequent dismissal or null pros because of the intervening indictments.
That's correct, and I think that's accurate. It really doesn't, it can't post hoc affect our interpretation of what the basis for the new trial order was. And, Your Honor, in this case does give the court an opportunity to clarify, as the appeals court correctly did, that the operative judicial relief is the judicial relief that vacates or reverses the conviction of guilt. So it's either a motion for new trial or a reversal on appeal. It's a judicial decision, not an unexplained null pros, an somewhat unexplained dismissal. And the reason for that is that you can look at the judicial decision. It's written. Discern its basis and evaluate as a question of law on the gatekeeper level whether it tends to establish actual innocence. So the legislature, in enacting the statute, we can tell that it was guided to some extent by other statutes in other jurisdictions that predated 2004. And some of the language was pulled directly from the New York statute, the language relating to having had charges dismissed and null prossed and being retried, which is somewhat more complicated, I suppose, in New York, and lengthy words there to describe what basically just means dismissed, null prossed, or found not guilty at retrial. But the gatekeeper provision here is different. It requires looking at a written document, either the pardon or the judicial decision, and evaluating whether it is on grounds that tend to establish innocence.
If we do that, don't you lose in this case? Because the motion judge did do written findings, and she said the testimony was crucial and is of major importance to the issue of the mistaken identity.
Right.
So,
I didn't have a chance to finish my answer, Your Honor. Yes, that's
but I
right.
mean, I know that you're arguing that, that's just a bad act, but the motion, but that should go to whether or not the motion should be allowed. It was allowed, and it was allowed based on a finding that this is critical to the question of whether they got the wrong guy.
I absolutely agree that it was critical to the defense in this case, or that it was important to the defense, because it went to the police officer's credibility.
That's not what she said, though. She didn't say it
Right.
went to his
I
credibility.
understand.
She said it went to mistaken identity.
Right.
And
That's
that's
true.
That's a question of innocence, isn't it?
Well,
But
I think that
well, yeah.
I think that by identity, though, there was no dispute here that Mr. Guzman was the person who showed up at the stash house. The defense was that he was visiting his friend, his cousin, Esteban Maffeo, which the Commonwealth said that was his alias. So there was this was not a classic case of identification. The tenant in the home knew him. They had talked. He had asked her for an oil company. He had exercised dominion over the apartment by talking to her.
Identity, you argue that identity probably means the sale at the Star Market, but doesn't identity in this larger sense, since the judge granted the motion, mean identity between him and the alias?
I think that it refers to the trial counsel in that case, in Guzman, described his defense in his opening statement as one of mistaken identity. But it became very clear by the end of the case, even though that was the way he cast the defense, that it was a constructive possession defense. In other words, he was trying to raise reasonable doubt that because Maffeo supposedly existed as a separate person, not as an alias of Mr. Guzman, that there was reasonable doubt as to whether all of the evidence that connected Mr. Guzman to this cocaine in his own name, documentary evidence, evidence of a neighbor who saw him, evidence of the bank officer who connected him to the money version, that reasonable doubt was attempted to be raised as to whether maybe the evidence was stronger as to Maffeo because the car that had the smaller amount of cocaine was registered in the name of Maffeo. All the other 4 cars in the case were registered to Mr. Guzman.
So if a defendant is somehow involved in these criminal activities. Even though they may not have charged him with the right crime, he's certainly culpable in the sense that he's a background criminal. He's lurking in the background of the case. He doesn't get to bring one of these civil actions. Is that what you're saying?
I think if anyone, I'm not sure I understand that Your Honor's
Well,
question.
you can get there can be DNA evidence, for instance, in a rape case that says that this guy just didn't do it.
Correct.
There can be alibi evidence that says that he was on an airplane at the time, and in fact he was flying the plane.
Correct.
But you seem to be saying something a little bit different here, that there's a quality of identity evidence that, yeah, maybe he's not guilty of this crime, but we'll get him next time. It falls into that category, and therefore he's not entitled to bring this action.
I think that the definition of actual innocence is that you are not innocent of the crime charged or any related felony. The prior bad act evidence was admitted to show intent to distribute. Intent to distribute is not an element of the gun possession charge. It would not be an element of the lesser included possession of cocaine. And moreover, you cannot use propensity evidence of a sale in a parking lot of a small amount of cocaine to show your propensity to be a big-time cocaine trafficker and to have constructive possession of a larger amount of cocaine. It's only relevant to the intent to distribute. And the fact that it went to credibility of the officer's view of it, and that it would have affected the jury's view of the evidence, conceitedly, you have evidence that maybe the officer was mistaken in his observations earlier.
But
that
Ms.
affects credibility.
It does, but isn't Justice Gantz right, though? If that was all, if this only went to what happened in the Star Market, it just seems unlikely that that would be a basis on which to grant a new trial, because if it's as sort of beside the point, as you argue, it's not likely to be the basis to grant that motion.
I think the appeals court decision really focuses well. I mean, we have the Superior Court and the appeals court decision in this case. And they say, a trial judge has very high discretion in deciding whether something could have affected the jury. She's seen the case. And this was a clear violation of a duty of loyalty to a client to actively attempt to keep out a Commonwealth witness whose testimony could have had an impact on the jury verdict and could have assisted him in his defense. If the wrong person did the prior cocaine buy, then the police officer's credibility is at issue. But I don't think that's the same thing as affirmative evidence that can tend to show he did not constructively possess the cocaine, where all of his comings and goings were documented not just by the police, but by a neighbor who knew him. And she saw him driving up. She describes the cars he was driving. So I would request that the court affirm the Superior Court in this case. Thank you.
Thank you, Ms. Sullivan. Mr. Rappaport?
Good morning. Stephen Rappaport for Umberto Guzman. As I started to say a few moments ago, underlying the judicial relief, and the judicial relief that we're focused on is the relief by the trial judge, the order granting the motion for new trial. There's an assumption, and that assumption is that the omitted evidence in this case was probative of the proposition that the culprit was another person, somebody else. Now, I would submit that, I don't know if it was Judge Cordy's question or Judge Gantz's question before, whether or not material exculpatory evidence, as we understand it in the criminal law, is comparable to evidence that tends to establish innocence, and I would submit that it is. First of all, if the burden upon the plaintiff was to establish innocence at the preliminary stage, there'd be no need for the word tends to establish. I would submit to the court that if you look at Commonwealth versus Ellison, material exculpatory evidence is evidence that tends to negate the guilt of the accused or stated affirmatively, supporting the innocence of the defendant. Now,
Mr. Rappaport, I'm sorry to interrupt you, but just for clarification, do you agree that the defendant moved to dismiss the charges against him on the grounds that the two police witnesses were under indictment and would not be available to testify, if at all, for at least 1 year?
No, Judge. First of all, I believe that it was Judge Quinlan who dismissed the case. She found, as a matter of fact, that the Commonwealth could not go forward on this case without the two key witnesses in the case, Sarah and Robinson, who at the time were both under indictment. They had not pled guilty to the various offenses yet.
Do you dispute that the court allowed the motion, in quotes, due to the unavailability of Commonwealth witnesses who now face federal indictments?
That's the Quinlan allowance of the motion to dismiss. The judicial relief that we're focusing on here is the trial judge's memorandum and decision in which she orders a new trial. I would imagine that both parties would agree that that is the operative decision. That's where we're focusing. And I would submit that, getting back to my point before, when we talk about material exculpatory evidence, we talk about evidence that corroborates the defense version of the events, in this case that there was a third-party culprit who was guilty, calls into question the Commonwealth's version of the events. One of the members of the court said that it couldn't have simply been Logan Spencer and what was observed behind the Star Market. The evidence against the defendant was as to the possession of the drugs that went into the trafficking charge and possession of the drugs that went into the possession with intent to distribute charge, constructive. What the Commonwealth presented in this case were two witnesses, Sarah and Robinson. These are the fellows who were later indicted. And I submit that when the trial judge allowed the motion for new trial, I believe that was 1994, in 96 the appeals court affirmed that allowance. All this time Mr. Guzman was sitting in jail. These individuals were not indicted, I believe, until 1997. So the judge wasn't somehow being prescient and saying the credibility of these guys was necessarily at stake. It is kind of interesting, though, if you look at the initial gatekeeper provision and then you look at what the plaintiff has to do at trial, whereas the prior case, while I don't want to get into it too much, we know a crime was committed in the prior case. Somebody was killed. The question is, who was the culprit who killed the victim? I would submit that when this case, if it goes to trial, this case may not go to trial on the basis that there's a third-party culprit. In this case, there's some reasonable question as to whether or not there ever was a crime committed by anyone other than the investigating officers.
But the judge didn't grant the new trial on that basis. So how can that
Well, I'm saying
help you?
At trial, I have to establish innocence.
I understand. You may, if you get past this stage one, when you go to trial, you can make that argument. But in terms of the stage one, that's not going to help.
That's all he was saying. He wasn't saying here.
That was the only thing I was saying. That's a major distinction between this case and that case. With regard to the order in this case, though, we do know that the evidence which was omitted did call into question the credibility of the only two, I would say, witnesses against Mr. Guzman. While we have...
What about the name, Mrs. McDonald, or whatever her name is?
Well, here's what she says. She saw, and if you read the transcript, she saw Mr. Guzman and two other individuals in the basement 6 weeks before the finding of 2 bags of cocaine and a gun and allegedly a betting slip inside a brown paper bag. I would submit that there's not even probable cause to believe that Mr. Guzman has an association with that brown paper bag.
Wasn't his name on the wedding slip?
Umberto was the name on the betting slip, and we know from that Maffeo also used the name Umberto. We also know from, I think it was from this woman, that what she identified as being in that brown paper bag was the gun and the two bags of cocaine, no betting slip. And I really have to ask the court, does it make sense that police officers who are executing a search warrant for serious evidence, that they're going to go back upstairs and speak to people and just to let them know what they found. I've never heard of anything like this occurring in a police search where they would allow neighbors into the
Well, the only, but
execution
didn't the
procedure.
record show that the only reason that they went down there at all was because she and her husband said you should check the boiler?
According to Robinson, Sarah had that information from an informant. According to Sarah, it didn't happen that way.
Okay, can I ask you a separate question? The Commonwealth has put into its brief this message from the governor that then got into the final legislation. Are you aware of any earlier legislative history, just in terms of what the legislature before that was intending to do?
It would appear that there was a less strict gatekeeper.
No, I understand that, but I mean just the genesis of the whole law to begin with.
Well, I think that we in the system are all aware of the fact that there have been numerous erroneous convictions shown over the past 15 years.
Right.
Much of these erroneous
On
convictions
DNA.
have been shown on DNA, which is the gold standard scientifically. We now know from the NAS report, the National Academy of Sciences report, which had been commissioned by the Justice Department, that perhaps forensically the only thing that we have
Right, but I just
is
didn't...
DNA.
So that's really my
Well, it's
question.
two things,
So-
actually. It's DNA and it's witness identification.
Well, we know, and I believe Judge Cordy in his dissent in Martin stated in 2006, that over half of the erroneous convictions that we found through this DNA testing are as a result of mistaken identification. There's no question that that's the case. And this is, after all, an erroneous conviction statute. And this is, after all, I would agree with the amicus in this case, that what we're really doing is we're searching for the truth. At the original trial, the truth-finding function was seriously prejudiced because of counsel's actually, the trial judge didn't find an actual conflict of interest in this case. There was a perceived conflict of interest on the part of the trial counsel, and as a result of that, and the court made a specific finding of that, the court had to find whether or not there really was prejudice to the defendant in this case, not just whether counsel was ineffective. Counsel was ineffective, no question. The question was the defendant, the now plaintiff, hurt by that ineffectiveness? And clearly the court found that his central defense was implicated in this. If this information had come to the jury would have been able to see, A, that there was evidence that somebody other than the defendant was the actual dealer in this case. They would have seen that the events did not occur as the Commonwealth's key witnesses said. For instance, Sarah and Robinson didn't merely say they saw a drug deal, and they did say they saw both of them stated they saw the exchange of money for white powder with Logue, and Robinson, Sarah as well said that he saw that same exchange with Spencer. What they talked about in this case was the first locus, where just I believe the lactose was found. They said that they saw this defendant meeting with known drug dealers, known drug users many times there. That was what they said they saw. With regard to the apartment where the large amount of drugs were found, they said that they saw Humberto Guzman carrying large bags, ostensibly one would think it's consistent with carrying cocaine, into that particular apartment. No other witness saw any of those activities. No other witness came into court to say anything of that nature. It wasn't just the alleged drug deal. This was a constructive possession case, and those officers used the Logue and Spencer transactions that they alleged they saw Mr. Guzman engage in, as well as other activities by Mr. Guzman that they said clearly supported the inference that those drugs were drugs that he had dominion and control over and intended to distribute. It would seem in this case that where in addition, when a motion for required finding was filed in the criminal case, the court should understand as well that the trial judge at that time viewed the evidence as very close in the case. The prosecutor had acknowledged that the key evidence in this case was Sarah's identification of Guzman as the seller to Logue, and even in the opening, the prosecutor had stated that when you add it all up, it all comes down to what Sarah and Robinson saw Guzman doing. Well, we now know that the reason why the court granted a new trial in this case, reversed the conviction in this case, was because there was serious question as to whether or not, had this evidence come in, a finding would have been made that it was Guzman engaging in all of these transactions. Because when you come right down to it, the defense was, it's not me, it's someone else. This evidence would have been supportive of that particular defense. It would have also called into credibility, as I say, the testimony of the two key witnesses in the case, and it would have certainly contradicted the Commonwealth's version of the events. Considering...
But I take it you're not suggesting that any time evidence is excluded, for example, that might bear on the credibility of one witness, and that exclusion, the court concludes, resulted in a trial that was not fair. Are you saying that's enough to meet this initial hurdle, even if there are multiple witnesses, for example?
Well, that comes into the... I believe that one has to look at that particular evidence in relation to the entire case in making its determination as to whether or not that tends to establish the innocence of the defendant. One would think that if it's material and exculpatory enough for a judge to grant a new trial on the basis of that...
Yeah, I think that the judgment is, well, this may have created a reasonable doubt. That's often the sense. This evidence may have created a reasonable doubt where one didn't exist before. Is that enough, you think?
Well, Judge, here's the problem with that. When we try criminal cases, innocence is not the issue. And it's never been the issue when we try criminal cases.
It is in the statute, though, which makes this complicated.
Oh, I understand. But when we look at what we do as prosecutors and defense attorneys and trial judges, innocence is not where we're headed. We're just looking to determine what the truth is. And if the truth is that it's been presented by fair evidence beyond a reasonable doubt that a defendant did a particular crime, well, he's guilty. The fact that there's less than evidence beyond a reasonable doubt doesn't mean that he's innocent. It just means he's not guilty. That's the only issue that we deal with at the trial level initially. I would submit, though, that when you take as seminal an issue as identification and you make a determination that omitted evidence went to the heart of that mistaken identification defense, at that point you're talking about evidence that tends to establish innocence. Does it prove innocence? No, not necessarily.
You would agree, though, that the way that, although the statute doesn't say tend to establish innocence, it does say tend to establish innocence of the individual as set forth, and then references the actual innocence part.
Yes.
So does it really tend to establish actual innocence?
Doesn't it support the innocence of the defendant below if it turns out that there was important identification, evidence that didn't come to the fore in the case, that would have specifically contradicted evidence presented by the Commonwealth, that would have absolutely contradicted the credibility of these people, and at the same time supporting the seminal defense? Isn't that tend to establish innocence?
I see it as tending to establish maybe a reasonable doubt. I don't know.
Well, as I say, the question of innocence was never before the case was tried initially.
Right, of course.
Thank you, Mr. Rappaport.